people had the CAC, Child Access Center interview had just been completed the day before, and or defense counsel had time to review them. There was a bond violation filed by the deputy here based on statements made by the victim in the Child Access Center interview that her mom had been contacting her either directly or through the grandma, which we staying with. The people admittedly do not have a victim present here today. I think it's going to have to be a situation where I have deputies physically go and get her along with her guardian who she's staying with. But I am going to ask for an adjournment for that purpose. I also think that an adjournment would behoove the defense in obtaining potentially a better offer, because my main focus here is seeing the defendant sober, seeing her as a sober parent, and any additional time sober is something I would consider an extending an offer.
Okay.
Yes, Your Honor. So we did adjourn the last preliminary examination, so both parties could review the recorded statement in which the child adamantly denies the strangulation, indicates that she made it up because she was mad at her mom and she had seen her mom being strangled before by her dad. And so that's where she came up with that. She also talked about people having rabies and a variety of other information that, you know, she's 7, so it's to be taken with a grain of salt. But my client adamantly denies the bond violation. She denies having contact with her since this case was pending. She denies the allegations against her in terms of any sort of assault, specifically strangulation, upon her child. So with that, she, we're here. We're prepared for the preliminary examination on the felony charges.
Your Honor, may I respond?
Yes.
I mean, since defense counsel is making statements and claims about what the victim said in the CAC, I would like to respond to those in that, yes, she stated that her mom did not strangle her. I will admit that. But she said that she called the police because her mom had assaulted her in other ways, and because her mom was so intoxicated that she tripped and fell with the baby in her hands, causing potential injury to the baby. And that this child did not know how else to get help other than calling the police and telling them that something maybe worse happened to her because she needed help from her mom, who was too intoxicated to take care of her, too intoxicated to take care of the baby. I have continued and ongoing serious safety allegations. I'm not even going to touch the rabies comment because that was made in relation to something that she also alleged that she saw the defendant do. So I'm just asking that this case not be dismissed today. If Your Honor is inclined to dismiss it, I will have the deputy return and I will at least begin the preliminary exam with very, very basic information.
Your Honor, Matt. But she, I don't think it's the credit for her get from the court. Please, you don't have medication.
Your Honor, again, my client denies the allegations. I'm pleased to report that she is sober and has been sober and is in treatment. So she's getting medication and she's in intensive outpatient treatment. She provided proof to my office. Regarding the adjournment request, obviously the court has the discretion to grant or deny the adjournment request. In this situation, it's unusual in that because she denied the initial charge, I don't think that people could reauthorize that charge. Obviously, they're free to interview her and to continue a remand as a misdemeanor. And I prepared Ms. Holloway for that, if that is to be the court's decision today.
What about Your client saying she didn't have any contact with her.
So, Your Honor, I have not never had any contact with her, period. Your Honor, I have not had any contact with Reagan, period. I have not been talking with Reagan through me or anything of that nature. I haven't even saw my daughter, and it's killing me because I love my kids. I do admit to being influenced.
I just think it's inexplicable that this child in the CSE stated that she was told that she's the reason her mom is in jail.
Yeah.
How else would she find that out?
Uh, because he didn't come home with me and talk to you, and I had to explain to her that's why. So
That is the part that frankly bothers me because presumably the child would not have known.
she got out of
Your Honor, the child did indicate she's living with multiple family members. Obviously, they're in the same family. So I don't know. Obviously, none of us know whether or not Ms. Holloway's had contact with her.
I hear you, but it seems just odd to me that the child says that and attributes that saying to a conversation that she's having with her mother. That takes a lot for a kid to do. I mean, if you look at those lines there, this child is very specific in terms of what she said.
May I submit an additional response? I'm not saying this is the case here because I don't know, but sometimes, I mean, Ms. Holloway was released after her arraignment, but she did spend some time in jail pre-arraignment. And again, I'm not saying this is what happened here, but sometimes she was actually released from the jail after her arraignment. So it is possible that she would have been on the phone with Reagan after she was arrested, before she was arraigned, before she was told not to have contact with her, and said something along those lines. Now, that I think at this moment, there is no specific information that it was a bond violation after she was released from jail. It could have been while she was in jail pre-arraignment, which wouldn't have been a bond violation. We would ask, if the court is inclined to grant the people's adjournment request, we would ask that her bond be continued. Again, there's no specific information that she's violated. I've been reaching out to her mom to try to talk to her this morning. Haven't been able to, but I'll continue to. And she's on these 2 tethers, GPS, Scram. There's been no violations of those. Since she's program, she's doing well. And so we would just ask that her bond be continued if the court is.
How would this child know, or in some way, fashion, or attribute it to her mother not to tell anyone that they've been talking?
Again, I have had this conversation where the court has to, make a determination as to bond, presuming her innocent, but also to protect her daughter in the community. I will say, that she starts to go into all of the people she's been living with in the family who's been talking to her about the situation. At one point, she just leaves the interview room after mentioning, yeah, my uncle lives with me. And then she leaves, and then she comes back talking about, I don't know which family members are talking to her. I don't know who is saying what. I understand that people are making allegation that Ms. Holloway is communicating with her. She's denying the allegation. She's simply asking that if the court is inclined to set this for bond violation hearing, or continue the preliminary examination or adjourn it, her bond be continued so she can continue her treatment, which at the end of the day is her goal is to stay sober, treatment. And this is she's known that she has faced going to jail all morning. I mean, she's been here. We've been talking about this all morning, and she understands how serious this is. We've talked again and again about the court orders. And even if this case was reduced to a misdemeanor, remanded, dismissed, I mean, the prosecutor and the court could still sentence her on contempt, right? On a bond violation. She understands that. She has never been in trouble before. She's trying to do right. She's trying to prove her compliance. And I know she's eager to speak up for herself. I've advised her to remain silent, but I know she's eager to tell the court that she wants to stay sober and stay in treatment so she can earn the privilege of reuniting with her children. I know she's working with the CPS caseworker as well, and complying with their plan moving forward. And I don't know if they have any additional information about this. I mean, last time I spoke with them was more than a week ago, so I don't know what information they have within the last week, but that could also shed some light if they were to have any additional information.
I did speak with this Yagi in that obviously was candid with her that my victim is not here today. And I wasn't opposed to, despite the allegation of contact, having the defendant's bond continued so that she can continue in this program and attempt to remain sober to be able to reunite with her children. I will say of note in listening to her jail calls when she was remanded on the past bond violation, it does appear she has a lot of support in her community, but a lot of recognition that she has a major alcohol problem, and if she wants to be around her kids, she needs to address that. So that was kind of my statement to Ms. Yagi, that I would be okay with her bond continuing, would give me another opportunity to try to get victim care so that we could potentially resolve this and get defendant, I think, the treatment that she ultimately very badly needs.
Normally, if the parties are in agreement on the bond, I would follow along with that without a lot of hesitation. Ms. Holloway, I'm just going to tell you, I've got a lot of concerns about you.
I have to say you.
Because every time when I release you the one time, you violate.
Your Honor, I have just.
You're back here, and when I released you on the 19th, I think it was, I then have this indicating that you're violating the bond. I have real serious concerns as to whether or not you take what this court says. If you want to tell me why I think I can trust you not to have communication, then here's your opportunity to tell me. But because I'll be honest with you, right now, I may be inclined to just send you.
Well, Your Honor, one potential additional assurance could be following up with the guardian. She signed the power of attorney over to her mother, who's, watching the child. And I don't know if the people have had any contact with her. I've played phone tag with her. I haven't actually spoken with her, but my client indicates that she, just like her godfather and I think her godsister's here, but they are like very strict and they take this court extremely seriously. And even if she hasn't proven her trust to this court, they are additional assurances that she will not violate. She will not have any mechanism from which to violate. Again, I'm not trying to say she would even violate, but even if she wanted to, she's saying that they would not let her because they are taking this very seriously and they want the end goal of reunification. I mean, this is a case where the interview seemed very clear that this is a case for reunification. And so the only way she could do that is by proving that she will comply. And understandably, the court has concerns. At this point, I would ask the court not to make a decision as to bond, perhaps set this for bond violation hearing. And maybe I could even subpoena her mom to come to court, like if it's helpful to shed light onto where this contact is coming from, whether it was pre-arraignment or post-arraignment or when. But that could be an additional assurance that the court would have is the people in her life that are taking this very seriously and that have the end goal in mind for her to reunify. And the only way to do that is to comply with it.
For the adjourned preliminary exam date, does the 16th work for the parties?
Yes, Your Honor. In 60.
Will that be enough time to?
Yes, sir, that works.
What I'm going to do in this case is I'm going to adjourn a preliminary examination to June 16th, 2020 before me. Of rights, Ms. Holloway. I really should lock you up. You should do that for the protection of the integrity of this whole process, because I think you run right up to the line, you jump over that line, and you don't think anybody's going to do anything. Last violation request, they're telling you to get out of the area, you don't do it. I think at that time you were still drinking, because then when they got you, they said, well, take a PBT, which quite frankly, in this court's mind would have helped you. You didn't take that. And frankly, my view is the reason you didn't take it is because you knew you'd been drinking. But you knew your bond condition was that you weren't supposed to be consuming any alcohol. Do I, as we sit here at this moment, believe that you had improper communication with your daughter? Absolutely, I do. Because nothing you say, at least at this point, I have any reason to believe. I let you out the last time. You're going to have to play by the rules. And if I find out, if I'm sure you violated those rules, you won't be coming out of that jail. There's going to be nothing anybody's going to be saying to me that may let you out. I'm going to let the people, you have to, I guess, I'm going to let you go today. Over my goodness knows I really do not want to. I'm going to give you that same admonition that I gave you at the last hearing. Something comes back to me that you violated to any extent, any of your bond conditions, I'm just going to lock you up. I really should be locking you up pending a hearing in this case. And if it hadn't been for what the people said and what the ultimate goal here is, I would. So you can thank all them for that, because my gut was telling me I should just lock you up. So you figure out which way you want to do it. I'm going to set a bond violation here for the same time as the preliminary examination. Come forth to me with additional evidence or any evidence, which I'm sure I'll make a decision at that time. May lock you up on that date. Just not doing it today. Quite frankly, I have little belief that you will make it to that date. This point or bond will continue.
Justice isn't just about the verdict, it's about understanding the law, the evidence, and the decisions behind every ruling. If you enjoyed this courtroom breakdown, please like, subscribe, and turn on notifications for more in-depth legal analysis. Thanks for watching, and we'll see you in the next case.